Welcome to the ceremony to mark the commencement of the Industrial Court of New South Wales and the appointment of the Honourable Justice Taylor as President of the Industrial Relations Commission and Justice of the Industrial Court. I invite Uncle Alan Murray, a descendant of the Wiradjuri and Koomilarai nations and chairperson of the Metropolitan Local Aboriginal Land Council, to welcome us to the Gadigal Nation.
This sort of reminds me when I was a young person, started my first job at Bankstown Courthouse. So, good morning to you. Welcome to Gadigal land. Always was, always will be Aboriginal land. Under the circumstances, should I do a bad thing or a good thing? But I would say this is that part of, I suppose, the stolen generations about the lost revenue that they couldn't receive before or after their, I suppose, their death, their timely death. So what it means to them is this, is that if they would have received an equal pay, even though working for a Aboriginal master, and the master was the gatekeeper caring for Aboriginal children, what does it mean today? Again, over a period of time, the legacy of the stolen generation is still part of us, and it's still part of us and to this day, you know. And the New South Wales government, listening to its officials to say they were going to increase its funding package, which is possibly a good thing. But also in terms of the best, I suppose, the best worked Aboriginal land rights system is in New South Wales. It doesn't apply to other states. And also, I suppose the other thing is that maybe New South Wales, and this is the problem that we've got in New South Wales, and that the treaty process is the last string, even though this is the place where colonisation took place, this is where it started. But I'm not going to go down that track. I'm going to say to you is this: all we want is fairness and the respect. If you walk into an Aboriginal clan's estate, you have to pay the respect and understanding to walk into someone's backyard and wait until you actually being received. Once you receive, we go into the dialogue, and that dialogue is about respecting one another, respecting this country. And as the chairman of the Metropolitan Local Land Council, we delve into issues about protecting our culture, protecting our sites, but also protecting our elders as well. Our elders mean a lot to us, like yourself in this room. There are a lot of elders in the room, and you know that the fortunes of having a better lifestyle compared to others is something like that. It's about others. And so with that, I pay respects to yourselves. Thank you for the opportunity. Thank you for allowing me to speak. Once again, I pay respects to Bangaroo, Padagaran, Pamawai, our greatest warrior, and Mosquito. And lastly, and I was at Bankstown Courthouse when I was a young fellow, and then handing documents to one of the magistrates. In the audience was Mum Shell. Mum Shell was in the audience and in the courtroom and wanted to have a cup of tea, and it was up to the magistrate to have a morning tea, and that was great. That was good, fond memories. So with that, I also pay respects to Mum Shell as well. So good morning to you. Thank you very much.
Thank you, Uncle Alan. Mr. Attorney.
Thank you, Registrar. May it please the Court, I acknowledge the traditional custodians of the land, the Gadigal of the Eora Nation, and I pay my respects to elders past, present and emerging. I acknowledge our Aboriginal friends and colleagues here this morning. Thank Uncle Alan for his welcome to country, and Your Honour, we ought to remind ourselves on an occasion like this where we regale the rule of law that sovereignty was never ceded over this land. Your Honour, on behalf of the New South Wales Bar and of our state, and indeed the Government of New South Wales, it's my very great pleasure to congratulate you on your appointment as a Judge of the Industrial Court of New South Wales and President of the Industrial Relations Commission. We welcome your wife Louise and your children Ellie and Nye with us today. Sitting with them are proud members of your family, including your mother Ariette and sister Juliet. Sadly, there are people who cannot be here with us today, including, in special mention, to your father Jonathan, who left us in 2019. We know he's watching today. I know you're grateful for family, friends and colleagues who are joining us in person and online today. Your Honour was born in Kingston upon Thames in the United Kingdom. You're the eldest child of Jonathan and Ariette. They were professional ballet dancers who continued to be creative throughout their careers. I'm told they named you after another creative visionary, Ingmar Bergman, one of the greatest and most influential film directors of all time. Living in a house with ballet dancers and their creative friends was unique. Ideas were always in motion. What you experienced at home, apart from all that creativity and motion, was hard work. Your father's working class background and your mother's wartime experience shaped them and helped inform your values. In 1979, life changed dramatically for you and your family when you migrated to South Australia, when your father was appointed as Artistic Director of Adelaide's Australian Dance Theatre. You've said that moving here presented you with more opportunities than the UK. Australia gave you a clearer path in life, one not marked by status or class. You attended Pembroke School in Adelaide. It was not love at first sight. It was a new place, and you were the English kid trying to find your way in a new land. They also didn't play soccer. AFL was the game of choice, but you weren't having a bar of any of that aerial ping pong. The only point, Your Honour, where you still get a point for missing. So under the guidance of a football-loving teacher, you were able to turn a lunchtime kick around with the round ball into a fully fledged team. These days, you're proud to note that the Pembroke Old Scholars now has five times more soccer teams than AFL. Well done, Your Honour. You did well at school and hung out with the clever kids, spending a lot of time playing Dungeons and Dragons and being involved in the arts. As you grew, your love of soccer continued and you played for the local Polish team. This opened your eyes to a new community and you loved playing with them. You loved that sense of family. Also growing was your worldview and your thoughts on the impact that you wanted to have on your community. Your emerging views were forged from your parents' outlook and cultivated through education and experience. Your philosophy was always about fairness. This manifested as a long-standing passion in politics. At the University of Adelaide in 1983, you studied politics as part of a Bachelor of Arts. A year later, you started your Bachelor of Laws. You figured that to master politics, it would be more than helpful to first master the law. You loved university both inside and outside of the classroom, and you thrived with your studies. You became president of the Students' Union and then graduated from university in 1989. You were admitted as a solicitor the following year. Since 1990, your career in employment and industrial law has been a testament to your dedication, expertise and the pursuit of equity and fairness. It began at Baker and Mackenzie, whilst also studying for a Master of Laws at the University of Sydney. From 1993 to 1997, you made significant strides at the Association of Professional Engineers, Scientists and Managers Australia, or APESMA. Starting as an industrial officer, you rose to become National Director of Legal Services. During this time, you not only represented the association in pivotal cases, but also established the in-house legal practice. You were called to the bar in New South Wales in 1997, having topped the bar exams. Commencing at Higgins Chambers and later moving to state chambers, you initially focused on industrial and union issues. You practiced and expanded to include substantial representation of the state of New South Wales as an employer. This period saw you involved in landmark work value cases concerning, amongst other things, nurses before the IRC. You became senior counsel in 2012, and in 2016 your journey led you to Greenway, the chambers you helped establish and where you have continued to excel. Your Honour is recognised for your expertise in industrial relations and work, health and safety law. Your impact has been profound, marking you as a preeminent authority in this field, witnessed by the many papers and training programs you've written, your support of junior colleagues, the leadership roles you've held and the esteem in which you are held. Your work for the Bar Association is particularly noteworthy. You were the Director, then Chair of the Professional Conduct Committee and Treasurer while being an executive member. You've been Editor of Bar News, the journal of the New South Wales Bar Association, since 2016. Significantly for many, you've also overseen a football World Cup tipping competition. It started in 1998 and has become legendary among your peers. There are many people in this room who today, and in the profession generally, that are a part of the competition. And frankly, Your Honour, they're concerned. Will this competition keep going? So let's give them some comfort. For the record, in this place I can say today, I can attest as Attorney General of New South Wales, completely without power, that the competition should continue, Your Honour. Your Honour, colleagues consistently say the same thing about you. Your Honour is someone who gives great confidence to others. This engaging personality translates well in court. You are disarming, professional and respectful. And it must also be said, you dress magnificently. Colleagues have told me that it's hard to have a cross word with you because of your calmness and fairness. You get on well with everyone, except for cats. Louise has offered that cats seem to dislike you, and the feeling is mutual. Others have found a few tiny faults. They say that your constant ums and ahs will keep the court reporters busy. And those closest to you believe fervently that you are quite fond of your own hair. And they say that becoming follically challenged is one of your biggest fears. So let's give some more comfort, Your Honour. Perhaps Your Honour might take comfort from the fact that this role comes with an optional gown and wig, should one ever be needed. Your Honour, today's appointment is a culmination of a wonderful career. Journeying alongside you has been your family. Louise is your #1 supporter and you, in turn, hers. You met on a dance floor in Perth. She was impressed by your moves and intrigued when you drank champagne from her shoe. You see, that was a pioneering shoey. A true act of Australian flirtation, just to show Louise that you weren't that English kid anymore. Louise loves that you've always tried to be your best, whether it's soccer, cycling, making school lunches, or just being her best friend. This enthusiasm flows into your love of travel and theatre. You've also been known to turn into Frank Sinatra at functions without any invitation or encouragement. Family and friends know you to be caring and loyal. They recognise that you've done the hard yards. You've prioritised family. You and Louise are super parents to Ellie and I, and they're both proud of you as well. Your Honour, this commission has a long and distinguished history. In fact, the Industrial Commission of New South Wales is the oldest industrial relations tribunal of its kind in the world. The Court of Industrial Arbitration, as it was originally called in 1902, was not only the first, but the preeminent industrial relations tribunal in this nation. It set workplace standards which were subsequently taken up by the Commonwealth Court of Conciliation and Arbitration and adopted by state and federal legislation. For example, in 1907, the Commonwealth Court handed down the famous Harvester decision, which established principles for determining the national minimum wage. But 2 years before, in 1905, Justice Hayden of the New South Wales Court in the Sawmillers case had already outlined the principles that should determine the state minimum wage. In Justice Hayden's words, a minimum wage should be adequate to ensure, and I quote, that every worker, however humble, shall receive enough to enable him to lead a human life, to marry and bring up a family, to maintain them and himself with, at any rate, some small degree of comfort, end quote. This court has always been responsive to the industrial problems of its time. In the 1980s, the Industrial Commission of New South Wales, as it was called then, led the way in developing standards for redundancy pay. After the economic recession and during the Christmas break in 1982, thousands of workers lost their jobs and the ranks of the long-term unemployed tripled. In response to these layoffs, the Commission handed down judgment in Crocker's case, which was the first judgment in Australia to set standards for redundancy pay. We owe our statutory rights of termination notice and redundancy pay in the Commonwealth Fair Act in large part to that decision. In 2000, the Commission established the equal remuneration principle as part of its wage fixing principles. And in 2015, it applied that principle to determine that the award rates of pay for Crown librarians, library officers and archivists, being female-dominated occupations, did not properly reflect the value of the work, precedents that have subsequently been applied in other states and at the federal level. The equal remuneration principle developed by the IRC does not require a male occupational comparator to establish gender-based undervaluation of wages. This was an important factor in the decision in the childcare workers' equal pay case in 2003. I note further that recent legislative change to the Fair Work Act has adopted this approach to equal pay in the federal system, a further example of the jurisprudence in New South Wales influencing the federal system. For most of its 123 years, the Industrial Relations Commission has been led by justices with a status equivalent to that of a Supreme Court judge. The amendments to the Industrial Relations Act that commenced on 1 July 2024, and I give credit to Minister Kotsis, who is an apology today, who is overseas, have restored that position. There have been so many changes to the industrial landscape since the court sat last in 2016, let alone since 1902. Still, Justice Hayden's words in the 1905 Sawmillers judgment are useful today as we usher in this revived court. He said, "It is idle to expect that decisions of the court will give satisfaction to everybody or be above criticism. But, bearing in mind the enormous advantage to employer, workmen and the public at large of the prevention of industrial war, I think it may fairly be expected that the decisions of a well-constituted tribunal should be, on the whole, beneficial to the community." Hear, hear. Your Honour, your leadership will ensure that this court is strong and independent, fair and reasonable, efficient and productive. You're a person of the utmost integrity, which will help create the safest and fairest of workplaces for the people of New South Wales, along with your brother judge and sister judge. I know you're extremely proud to be appointed to the Industrial Court and you're eager to get started. And so can I say in conclusion that the best wishes of the Premier, the Cabinet and all members of the New South Wales Government go with you, Justice Chin and Justice Pangakalam. The Court has been revived. It is a proud day for our government and for the Labor movement. And now, as they say, it's all up to you. Godspeed. May it please the Court.
Thank you, Mr Attorney. Mr McGrath.
May it please the Court. I acknowledge the Gadigal of the Eora Nation, the traditional owners on the land on which this court stands, and pay my respects to their elders past and present. I acknowledge and extend my respect to all Aboriginal and Torres Strait Islander people here with us today. Your Honour, on behalf of the Solicitors of New South Wales, it is a privilege to be invited to address this court to mark the exciting new chapter in our state's legal history. Today we mark not only the commencement of the Industrial Court of New South Wales, but also Your Honour's appointment as President and Judge. We celebrate the start of a new chapter in industrial relations law in New South Wales, almost 125 years on from when it first began. As the attorney outlined, originally established in 1902 as the Court of Industrial Arbitration, it has seen several iterations throughout the 20th century, existing as a separate entity at various points until 1926, when it was dissolved and replaced by the Industrial Commission of New South Wales. The Industrial Relations Act of 1991 saw a revival of the court, tasked with handling civil matters, prosecutions and legal issues. A 1996 reform subsequently streamlined the system and merged the court back into the broader Industrial Relations Commission. Then the Industrial Relations Act of 2005 enabled the Commission to be called the Industrial Court of New South Wales in court sessions. However, in 2016, this was once again dissolved when all industrial disputes and matters relating to work health and safety in New South Wales were transferred to other courts. Almost a decade on, here we are, the first day of the new Industrial Court of New South Wales and welcoming its new president. Your Honour, while you were only a member of the Solicitor Branch of New South Wales from 1990 to 1997, your colleagues from that time have recalled the early buds of what would blossom into a remarkable legal career. In testament to Your Honour's skills and your character, we have received glowing references from your two bosses from your time as a solicitor. They are in attendance here today, and while they too can take pride in your accomplishments, they both express how very proud they are of you. After your admission as a solicitor in 1990, Your Honour spent 3 years as an associate at Baker McKenzie in the litigation section where you specialised in employment law. It was here that Your Honour was first introduced to industrial relations, working alongside your first boss, Fiona Inverarity. This area of law was to become, in the words of another person we spoke to, the bedrock of your career, a foundation that has culminated in today's celebration for your appointment. Ms. Inverarity recently recalled her earliest memories of Your Honour was, in her words, a summer clerk and a very baby lawyer. Even though some years have passed, she remembered your empathy for the work and how you always thought deeply about what would happen to the workers caught up in disputes. Your Honour was always incredibly principled in how you approached your duties. Now, that does not mean that there was no time for any humour or lighter moments. In years gone by, it was standard practice for an affidavit to note that a writer was above the age of 16 years old. At the time Your Honour was working for Ms. Inverarity, she was approaching 30 years old and with mixed feelings about that milestone. Your Honour was still a number of years away from that significant birthday. And it was with humour that she remembered receiving a draft affidavit prepared for her by Your Honour that noted, and I quote, "I'm a lot closer to 30 than 16, just in case you needed the reminder." Aside from this workplace banter, in your early years as an industrial relations lawyer, Your Honour took particular care in attempting to understand a workplace holistically and from all perspectives. From Baker McKenzie, Your Honour went next to the union, now known as Professionals Australia, where you spent 4 years as an industrial relations advisor, advocate and in-house lawyer. This move perhaps seemed a natural next step for someone already making an impression as an industrial relations lawyer, though it seems that something else drove Your Honour to make this application. Your boss from the union, Martin O'Connell, recalled that included in the association's salary package was a new vehicle. In making your case for this position, Your Honour very honestly disclosed, and I quote, "I have an ancient Morris 1000, so I'm interested in replacing my car." No matter what steered Your Honour to this role, it was a position in which you excelled. Mr. O'Connell said that 3 things he recalled most consistently from Your Honour's time there were your commitment to clients, the thoroughness of your preparation, and the depth of your legal understanding. In 1997, Your Honour went to the bar, as we have heard, having topped the entrance exam for your cohort. You took silk in 2012 and have assumed your place as one of the nation's leading industrial relations barristers, acting for unions, large and small employers, and the New South Wales Government. Your Honour is known for your enduring loyalty to your family, including your wife Louise and your 2 children, and to your friends. Dinner conversations are always lively and spirited discussions of current events. A keen cricket fan, Your Honour can often be spotted on a summer's day enjoying a test match. As one member of your cricket clique remarked, "You could not find a better friend than Ingmar." And based on the breadth and depth of your experience, New South Wales could not have found a better president of the new Industrial Relations Court than Your Honour. So well done. On behalf of the more than 42,000 solicitors of New South Wales, we wish Your Honour, and indeed the Industrial Relations Court of New South Wales, the very best in your endeavours, as the court pleases.
Thank you, Mr McGrath. Mr Murray.
If it pleases the Commission, I'd like to acknowledge the traditional custodians on whose land we meet today, the Gadigal people of the Eora Nation, and I pay my respects to elders past, present and emerging. New South Wales has a long history dating back to the stonemason strike of 1856 for the 8-hour day. Almost 100 years ago, the Industrial Commission commenced its work of arbitrating disputes over pay, working conditions and the resolution of strikes. Today's ceremony is one of the final steps in the re-establishment of the New South Wales Commission as an independent jurisdiction in New South Wales. The New South Wales Union Movement acknowledges the commitment of the Minns Labor government to restoring the Commission and the industrial judicial functions. I would also like to acknowledge the Attorney General Michael Daly and the Minister for Industrial Relations Sophie Costas MP for their commitment to and work to re-establishing the commitment for the benefit of essential workers in New South Wales and the broader New South Wales community. In 2011, the former President of the Commission, His Honour Justice Boland, presented the Jeff Shaw Lecture at Trades Hall. This occurred while the previous government moved to legislate to shackle the independence of the Commission by removing the court function and legislating a wages cap. In his speech, His Honour succinctly captured the essence of the role of the New South Wales Industrial Commission. His Honour said, "The Act provides an unparalleled framework for the conduct of industrial relations that is fair and just. It was drafted following extensive consultation with employers and unions. The Act was drafted with a view to the best model to meet the interests of the industrial parties and ultimately the people of the state. The Industrial Relations Act of 1996 continues to serve the people of this state well, essentially at its heart, the great Australian value of the fair go. The 1996 Industrial Relations Act has stood the test of time. A small tract compared to the voluminous pages of the Fair Work Act. Yet its simplicity belies the ingeniousness of its power to enable the making of decisions under a series of principles, no matter how specific the circumstances of the case, that case can be resolved. Such was the confidence in the effectiveness of the Act and the New South Wales Commission, our movement and my predecessors often argued its adoption at the national level as a model on more than one occasion. The current income inequality and the continuing concentration of wealth within a smaller and smaller cohort of Australians arguably justifies their position. The need to restrain an active state jurisdiction to moderate the excesses of a federal system based on the corporations rather than the arbitration and conciliation powers of the Constitution remains a reality for over 400,000 essential workers in our state. A one-size-fits-all limited industrial system does not assist an economy or a state as large as New South Wales. The balance and independence of the Commission is fundamental to its effectiveness and retaining the confidence of those who appear before it. Much of the work done in this place, and I mean literally this place, often unrecognised, was essential to the stability and the success of the New South Wales economy. There is now an opportunity for Your Honour and the Commission to continue the vision of the Honourable Jeff Shaw to be bold and innovative in the way it will manage the matters that come before it. For working people, many with limited financial means and resources, I hope this Commission will become a place where justice can be sought and achieved. For the union movement, we are hopeful the Commission under your stewardship will be an innovative place where there will be a fair go for workers. This doesn't mean the Commission will always deliver the decisions we would like. However, if it is a court which is trusted, respected, innovative and provides a fair go for all, then it will go a long way to ensuring New South Wales is a state which can retain and attract the best essential workers in the country. In turn, this means we'll have the best public services in the country, and in a cost of living crisis, the public sector and the services it provides becomes even more important for the betterment of our communities. I know, Your Honour, that brings a great intellect and integrity to your new role. I believe your vision, leadership and stewardship of the Commission will ensure a trusted, respected and innovative court that will provide a fair go to the workers of New South Wales. I congratulate you on your appointment and wish you all the best in the years ahead, if the Commission pleases.
Thank you, Mr Morey. Mr Dancy.
If it please the Commission. In rising to speak, I acknowledge the numerous distinguished guests in attendance, and I join others acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I also make my usual disclaimer when speaking at occasions such as this: nothing I say here today is to be used against me in court. It's a great privilege to address the Commission today on behalf of local government as we recognise the re-establishment of the Industrial Court of New South Wales and welcome His Honour Justice Taylor as President of the Court. Justice Taylor, I'm advised you share similar views to one of my former employers about representation by lawyers. And noting on the last guest speaker today, finding content the other speakers haven't already used has been a challenge involving great complexity, even for a lawyer. It's appropriate I start by saying a few words about the reconstitution of the court and restoration of the Commission's powers and functions. All the industrial organisations who represent local government in New South Wales have advocated for the Commission's powers and functions to be restored for some time, and we are delighted to see it finally happening today. I commend the New South Wales Government and in particular the Honourable Sophie Costas MP on getting the job done and on making 3 outstanding appointments to the court. According to the Commission's website, the court was formally reconstituted on Monday the 1st of July at a ceremony in Queen Square, Sydney. So why are we here today, you might ask? If 1 July were to have marked the official reconstitution of the court, it would have coincided with the day in history when the first ever video was uploaded onto YouTube in 2005. The video was titled "Me at the Zoo," which is perhaps how His Honour will feel by the end of today. 9 July is a much more appropriate day in history for an occasion such as this. On this day in the year 1900, the Australian Constitution received royal assent from Queen Victoria, establishing the Commonwealth of Australia. And I must admit, it didn't actually occur to me until hearing from the other speakers that we now have somebody whose ancestry has come from the UK leading this great court. Today's ceremony is taking place in the Chief Secretary's building, which was the Industrial Court's last home back in approximately 2018. During the late 1800s, the building was occupied by Sir Henry Parkes, who is often referred to as the father of Federation, and used for some of the forums which led to the making of the Constitution. And the forums included debate about the reach of the Commonwealth's powers with respect to industrial relations and corporations. Now, Justice Taylor, you are no stranger to constitutional law. Throughout your career as a barrister, you have fought valiantly in several constitutional law cases as defender of the jurisdiction of the court over which you now preside. Notably, as in 2006, you appeared before the High Court assisting Michael Sexton SC in the workplace relations case. The workplace relations case has similarities to another significant event on this day in history. On 9 July 1958, an earthquake in Latuya Bay in Alaska caused the highest wave ever recorded in in history, I should say. And watch from the tsunami reached a height of 520 metres. And just like the workplace relations case, where the High Court's rejection of your arguments washed away all hope of a return to a pre-work choices industrial relations, the tsunami wiped out everything in its path. Your Greenway Chambers profile indicates that you are an avid supporter of the Sydney Swans. This led me to wonder whether you ever ran any cases before Commissioner Liz Bishop, another avid Sydney Swans supporter. I came across the case Australian Services Union versus Sydney Water Corporation. It's unnecessary on this Super Tuesday for me to indicate the outcome of the case. Suffice to observe, sometimes being a Swans supporter isn't enough. The case also led me to wonder whether you are a typically average Aussie bloke. And if for those that are not sure where that comes from, go back and have a look at the case. It's a well-known fact you have the best head of hair of any Commission President to come before you, which already means you're not an average Commission President. We've also heard you came first in the bar exam, which suggests you're a cut above the average lawyer. Your Greenway Chambers profile also indicates that Ingmar works entirely electronically, so prefers that all documents are sent to him in PDF. This suggests you are ahead of the curve when it comes to embracing innovative technology. It's been brought to my attention that in 2023 you gave a presentation at the Union Lawyers and Industrial Officers Conference on the topic, The Paperless Advocate. And by all accounts, it was a very impressive presentation, which included a demonstration by you on how to convert any document into PDF, sort documents into folders, and share those documents instantaneously by electronic means to whoever may require them. Unfortunately, your presentation was lost on some of the industrial officers who don't own iPads, Surface Pros or laptops. And many in today's audience will, and no doubt, find that it's ironic to have someone so ahead of the technology curve who now presides over an institution that is not known for its use of technology. It's great to see that you're already having an impact with a revised Practice Note 32 being released on the 1st of July, increasing the availability of filing by electronic means and expanding the range of forms that can be filed using the online registry. I'm advised that when you played soccer for Sydney Uni, you were a dashing winger. Unfortunately, 2 ACL injuries prevented you from playing soccer beyond the level of a typically average Aussie bloke. However, your disappointment in not being able to represent Australia at the Soccer World Cup may have been what inspired you to later run the Not the Bar Association World Cup footy tipping competition. And despite developing the rules for the competition, I'm reliably informed you excelled at being a typically average Aussie bloke when it came to picking a winner. There are, of course, stories about what you got up to at Industrial Relations Society conferences in your younger years, but unfortunately for the audience, as a fellow IRS member, I'm bound by the IRS code, what happens away stays away, and can't share these stories with you today. I'm advised the first case you ran as a barrister was before Her Honour Senior Deputy President Lee Drake. The matter was unable to be resolved and dates needed to be set for hearing. When asked about your availability, you indicated you needed to consult your diary, and in response, Her Honour responded with words to the effect, "Mr. Taylor, we all know it's your first day at the bar." So just like the typically average Aussie bloke, your cheeks turned a rosy pink colour, as did Her Honour's, who was embarrassed that she had embarrassed you. I know you have several family here with you today to share this special occasion, including your wife Louise, your children and your mother. Everyone I've spoken to about today, which includes people from the unions, employer associations, lawyers, judges, are unanimous in their view that you are hard-working, inclusive, very knowledgeable and experienced about industrial relations and work health and safety, and have all the attributes to make a great Commission President. You may not be the typically average Aussie bloke, but you are the obvious choice to lead the Commission as President. So on behalf of Local Government New South Wales and the local government sector generally, I congratulate you on your appointment. I wish you well and look forward to the valuable contribution you will make to the Commission and the people of New South Wales over the coming years, if please.
Thank you, Mr Danzi. Justice Taylor.
Ninyali Ningala Wagnam Mabudgari Gadi Nurada. We are sitting here on the beautiful land of the Kadi people, the Gadigal. I acknowledge their elders, past and present, and extend that acknowledgement to all other Aboriginal and Torres Strait Islander peoples here today. We were honoured by the welcome to country by Uncle Alan, and I thank him. Thank you too, Mr McGrath, attorney, Mr Morey and Mr Danzi, for your kind words about the court and your kind and sometimes true words about me. Welcome, distinguished guests, judges, members and commissioners of the various courts and tribunals, my colleagues, friends and family. It's an honour and a joy to have you here at this welcome ceremony for the Industrial Court of New South Wales and my appointment, whether you are here in the courtroom or in the various overflow areas. In theatre, it is standard practice to pick a theatre size that guarantees a sellout. As the attorney mentioned, the Commission has a long and proud history. It has, over its 123 years, set multiple conditions that became national standards. The Commission, and now the revived Court, continues to have an important role in setting fair pay and conditions in a manner that promotes innovation and productivity. Early in my career, I had the privilege of being led by the author of the New South Wales Industrial Relations Act, Jeff Shaw QC, Attorney General and Minister for Industrial Relations. In simple and direct language, unburdened by the myriad of mandatory considerations found in the equivalent federal legislation, some 10 times as long, the Act confers on the Commission powers to resolve disputes by setting actual conditions of employment by reference to the simple criteria that they be fair and reasonable. The High Court Work Choices case, which Mr Danzy was good enough to point out that I lost, reduced the jurisdiction of the Commission, but the jurisdiction remains important. It covers all local government employees and all state public sector workers. That's nurses, police officers, teachers and school support staff, correctional officers, ambulance officers and firefighters, amongst others. Our society's most valued workers and professionals. Since the Court last sat in 2016, the COVID-19 pandemic has reinforced how our society depends upon these frontline workers. The Commission's importance is also emphasised by its economic impact. Just a 1% increase in public sector salaries equates to about $2 billion over 4 years. The amendments that re-establish the status of the Commission also repeal the section that empowered the government to impose what became known as the wages cap. Its removal has the effect of reinstating Jeff Shaw's broad and unfettered power to arbitrate where conciliation is unsuccessful. This in turn enhances the Commission's primary duty to do everything that seems to be proper to resolve a dispute by conciliation. The resurrection of the Industrial Court also sees the return of the important work health and safety jurisdiction. Nobody should die or be seriously injured because their workplace is unsafe. It's been enormously exciting to oversee the start of the new chapter of this historic institution. The amendments and our appointments took effect last Monday on the 1st of July. 56 applications for increased pay and conditions were filed. I listed them all last Wednesday, and it was so good to see a courtroom here again filled with industrial advocates. When I was a junior solicitor, then industrial officer, later junior barrister, I appeared regularly before the Industrial Relations Commission in this building, indeed, in this very court, before my 3 predecessors as president. They're here today, Justices Lance Wright, Roger Boland and Michael Walton. My ultimate ambition then was to be appointed a judge of the Industrial Court of New South Wales. And I am genuinely honoured and excited that that has come to pass. The importance I place on industrial justice, as the attorney said, I'll start again. The importance I place on industrial justice and work health and safety, I gained from both sides of my family. My father was born in a small back-to-back house in one of the poorest parts of Manchester in the north of England. Industrial dust was everywhere. cleaned the kitchen top, and an hour later, a wipe of your finger revealed a layer of black dust. 5 years ago, he died of pulmonary fibrosis, a lung condition which the specialist attributed to what he had breathed in as a child. He would have so loved this occasion. His father was a boilermaker. His mother, my granny Biddy, was a furrier. Dad was a real-life Billy Elliot. At the age of 15 years, he went to London by himself to study ballet full-time. He was trained by the Royal Academy of Ballet and went on to become a professional dancer of renown, featured on billboards across London. My mum, who's here today, was born in Amsterdam to an educated middle-class family. She recently gave me this doctorate in law thesis, written by her grandfather, Isaac van Rossum, in 1889. It's titled, Concerning Judgments of Disputes Between Employers and Workers. Amongst other things, it calls for compulsory mediation before arbitration. Now, mediation in Dutch is verzoening, derived from zoen, to kiss, an expression that some may think has a more romantic ring than mutual gains bargaining. After living through the Nazi occupation, Mum too became a professional dancer. Later in life, she became a successful theatre director and has directed for leading companies, including the Sydney Theatre Company. My parents met in 1961 as young dancers in Amsterdam, and within 6 months they were married and dancing at Ballet Rambert in London. Dad was 21, Mum was 22. I was brought up in Richmond, London, the eldest of 3 children. For a while, I did ballet classes at the same dance school as my father had studied. Mum remembers picking me up from the underground and me standing on the platform at peak time shouting, "Look, Mum," and proudly demonstrating my tour en l'air. By his mid-30s, my father's dancing days were over, and as the attorney said, he was offered the position of artistic director at the Australian Dance Theatre. And so my family, including my 2 younger sisters, both of us here with us today, emigrated to Australia when I was 11 in 1976. When my twins turned 11, I reflected on what a momentous decision that must have been for them. We arrived in Adelaide in early November. It was hot, really hot. We stayed for the first 2 weeks in Scotty's Motel, which features a 5-metre concrete Scotsman in a kilt, one of Australia's first big things. Nearby were the Adelaide parklands replete with yellow grass, hiding a multitude of 3-cornered, razor-sharp bindies. Talk about culture shock. All 3 Taylor children worked as professional actors at one time or another. Indeed, my first union was Actors' Equity. None of us, however, ultimately pursued theatre careers. Juliet went to NIDA, but then qualified as a primary school teacher and became a principal. Reby is an associate professor of history at the University of Tasmania and the award-winning author of 2 books. Now, no one gets to a position like this without mentors. My first, at Baker & McKenzie, was Fiona Inverarity. This was at a time when even large firms had no more than 1 associate doing employment law. As a result, when Fiona went on leave, I was instructed to send my draft letters to her friend Lynn Burns, who worked at Mallison's, 6 floors above us. Next, as an industrial officer at APESMA, New South Wales Director Martin O'Connell taught me how to understand the human dynamics of an industrial dispute and demonstrated how to be a good leader. From there, I went to the bar, starting at HB Higgins Chambers on the same day as Adam Hatcher, now President of the Fair Work Commission. Those formative years at HB Higgins Chambers led to strong friendships, including 3 I'll mention. my Vice President, Justice Chin, Mark Gibeon, now Vice President of the Fair Work Commission, and Petros Gintas, who we all sadly miss. In my early years at the bar, I had the privilege to learn from the best. Richard Kenzie KC led me in the High Court on a number of occasions, and in my view was the preeminent industrial advocate of his time. While Max Kimber SC, my excellent tutor, taught me, amongst many other things, how to identify what in a case is red hot. I've made many great friends at the bar, including at State Chambers and then at Greenway Chambers and on Bar Council, who've all lifted me and assisted me in so many ways. I'm glad so many of you are here today. I look forward to our continued friendships. And Attorney, it's good to hear approval from the First Law Officer of the state for the continuation of the Not the New South Wales Bar Association World Cup tipping competition. Finally, I want to thank some people. First and foremost, my wife Louise, the love of my life, my most valued advisor, and my best friend. There's nothing I enjoy more than being with her. My two children who are here today, Ellie and Naya, from whom I have learned so much. Ellie, who's a rower and a photographer, lifts the spirits of all those around her and is a strong advocate for equity. Nai, who's about to start a doctorate in pure mathematics, is a thoughtful young man with outstanding values. We are so proud of them both. And Dominique Elder, who's worked for me for 20 years, who's followed me to the court and is sitting below me today. She was instrumental to my success at the bar. Can I thank Una Doyle of the Judicial Commission and the Judiciary for their warm welcome. We have been overwhelmed by the goodwill of so many. Can I thank my registrar and my fellow commission members for being so welcoming, and my fellow new justices, Chin and Panaculum, for their work and collegiality since our appointments were announced. I am really looking forward to our years of working together. Thank you to our staff, including our stage manager for today, my associate, Rebecca Serralio, for organising this event, and my thanks to all of you for being good enough to join us today, either in person or online, to mark the re-establishment of the court. We're about to adjourn. You're all welcome to join us for the morning tea in the room behind us. In the words of the Gadigal, Didjirigora Yana Yanawi, thank you for walking with me. Let's walk forward into the future together.
All stand. This Honourable Commission is now adjourned.
Door's locked. Is that right?
Constantly tapping.